In each of these matters, Mr. Grant is here today after failing to appear before referee Delmont on October 31st, 2022. In the first case, bond is currently set at $2,193. This is the first bench warrant. In the second case, bond is currently $775, and this is the second bench warrant. He reports that he is employed. Last payment made on these accounts was in May of 2022. Front of the court recommends that reasonable bonds be set in each of these matters, and they be scheduled for hearing on March 15th, 2023 at 8:00 a.m. before this court.
Okay. Mr. Grant, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 15, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Oh, no, sir.
Okay. Well, I am going to give you some consideration for the fact that, this is your first bench warrant in one case and the second in the other. But court does note you haven't paid, going on a year. So what I'm going to do is I'm going to set your bond in both cases in the amount of $100. So if you're able to post that, you'll be able to be released. Do you have any questions, sir?
Oh, no, sir.
Okay. Thank you. Court will end this matter to all of you. 2 a.m. You're free to go. Have a good day. I'll go to you first, Mr. Krieger. Again, there's a consent judgment in this matter. Did you in fact sign those documents, sir?
I did.
Okay, so you're not disputing and you're not contesting anything, correct?
I am not.
Okay. Then, Ms. Krieger, we're going to have some testimony taken from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Okay, Ms. Greenlee-Clore, you can proceed.
Thank you. Angela, at the time you signed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
A resident of the county of Calhoun for at least 10 days?
Yes.
Were there any minor children born of this marriage?
Yes.
And is there any chance you could currently be pregnant?
No.
Has there been a breakdown of your marital relationship?
Yes.
Can you give the court a brief reason for that breakdown?
We are no longer able to get along.
So if this court were to not deny your divorce for any reason, would you go back to living as husband and wife?
No.
And you recall signing a consent judgment of divorce, correct?
Yes.
And you believe that the property settlement in that judgment of divorce is fair and equitable?
Yes.
Do you believe that the parenting time in that judgment of divorce is in the best interest of your minor children?
Yes.
And you also remember signing a motion to opt out of front of the court services, correct?
Yes.
And you've been apprised of your rights and responsibilities regarding opting out of front of the court services, correct?
Yes, I have.
And you're asking that this court also not only enter a judgment of divorce, but also sign an order opting out of front of the court services.
Yes.
Thank you, Your Honor. Nothing further unless you have additional questions on me to ask.
No, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Court will note the defendant has appeared and acknowledged his signature on the judgment, the UCSO, and the opt-out. And as a result, the court will enter the judgment and the UCSO as submitted in this matter. When I get that signed right after that hearing, that will conclude your case. You will be divorced. And I tell you, best of luck to both of you. I hope everything works out. And the court will end these proceedings at 8:36 a.m. You're free to go. Have a good day.
Doug,
Thank you.
Hello.
can you maybe
Just a minute, I have to make a few. Take this off or chat off.
Court will note the appearance of Ms. Reed on behalf of the plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the defendant's motion to show cause. Mr. Todd.
Thank you, Your Honor. Your Honor, the short and sweet of this motion is that there was an order with the court from a previous order, which granted the parties basically alternating tax claiming for the children. This was subsequently modified in 2023, but it was never modified necessarily for fiscal year of 2022, nor was there any agreement written in the order that this would be retroactive. At this point, the plaintiff claimed both children for fiscal year 2022, and that must have been done prior to entry of the most recent order. The most recent order was not entered until after she claimed the children. So we believe that the plaintiff should be held in contempt, and that the defendant should be able to claim one child for tax purposes for the fiscal year of 2023. And then moving forward, that the party's order from 2022 would be active.
Okay. Ms. Reed, your response.
Your Honor, we specifically negotiated that my client would be claiming all of the children for every year. As part of that would be that we would not be seeking imputation of income to Mr. Maury in the hearings that were scheduled on our motion to modify parenting time and child support and Mr. Maury's motion to modify child support. And that is reflected in the order that Mr. Maury signed, that my client would be it was signed in the middle of January, that she would be claiming both the children each year. And that's what we are holding Mr. Maury to. And now he's trying to selectively pick and choose which parts of the order he wants to follow and which parts of the order aren't applicable. Part of that negotiation was also because Mr. Maury is tens of thousands of dollars behind in his child support. So now he's trying to undo this order to financially impact my client, incur her additional attorney's fees, and he's not negotiating in good faith. And we would argue that the order was signed in the middle of January. My client claimed those children on her taxes in reliance on the agreement. And we disagree that the order from 2022 would go forward, as my client is agreed and Mr. Maury signed that she would be claiming them each year. So we're requesting that the motion be denied and we be awarded attorney's fees.
Okay. Well, when the court looks at the case, I have reviewed the prior orders of this court, and it did provide that the parties would each claim one minor child. And as stated today, and is in the pleadings, that the new order was not signed until January 2023 and not entered until, February 10, 2023. And the court does operate through its orders, and there was not an order in place that countermanded the prior order until 2023. So the court does believe that Mr. Todd's position is appropriate in this particular matter. The court will not hold the plaintiff in contempt because she didn't violate a court order. And there was obviously issues concerning that. But the fact remains that in 2022, based upon the orders of the court, the parties were each entitled to claim one child. And so because she has done that, the court will grant the defendant's request to allow him to claim one child in 2023. And after 2023, then the order that went into place on February 10th will control, and she will get the deduction at that point. So, Mr. Todd, you can prepare that order and submit it under 7-day notice of entry.
Thank you, Your Honor.
That will conclude this matter at 9:06 a.m. You're free to go. Have a good day. Did we ever have, I don't think I'd ever had I didn't see a response from Mr. Bailey.
I did not.
Okay.
Response.
Good morning, Your Honor.
Good morning.
Attorney Bailey, you are muted.
Now, how's that?
Okay, that's
Oh,
better.
perfect.
Court will note the appearance of Mr. Bailey on behalf of the plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to change custody. I've reviewed all of that, so Ms. Henderson, you don't have to reiterate everything if you want to highlight. And then Mr. Bailey, I don't believe I received a response that.
Your Honor, I was only retained Thursday afternoon.
Okay.
I did not have time to do a response.
After Ms. Henderson's done, I'll let you then respond. Go ahead, Ms.
Thank you very much.
Thank you, Your Honor. As the court has reviewed our motion, essentially there are proper cause and change of circumstances in this matter to review the legal and physical custody of the parties. The judgment entered in December. Since that time, there have been significant changes. Specifically, plaintiff is about to lose her housing. She was set to be evicted on February 7th. She got an extension until February 23rd, at which point the court was closed in Kalamazoo during the ice storm. So it is uncertain at this point how long she will be able to maintain her housing. She does not have transportation pursuant to the court orders. The vehicle that she was awarded was subsequently awarded to my client due to her non-payment on the loan, and my client is mitigating the financial loss for both parties at this point. Without a vehicle and stable housing, obviously the children will be at risk of harm, both physically and emotionally, and may not be able to attend school or other activities. There have been multiple reports of plaintiff drinking and partying in violation of provision of the judgment of divorce, specifically prohibiting such behavior during the parenting time. Minor children reported to my clients having weapons lying around the home of plaintiff and being accessible to the minor children. Plaintiff continues to violate the provisions of the judgment and subsequent court orders that mandate the parties to take the children to the agreed upon activities and counseling, and further continues to not provide my client with our family wizard code that would allow the parties to communicate via the app. To defendant's knowledge and belief, plaintiff is not employed and is not able to financially provide for the minor children. Specifically, the event that made my client file the motion was when the children reported to police officers sent to defendant's home upon his knowledge and belief by plaintiff that they do not feel safe returning to their mother's home. And at that point, my client was advised to file appropriate motions in court and not return the children to plaintiff until their safety can be verified. Defendant already filed an ex parte motion seeking modification of parenting time that was granted by Judge Jules Johnson during your vacation, Your Honor. And currently, the parenting time of plaintiff is supervised only. To my knowledge and belief, plaintiff only exercised her parenting time once or twice in the last month due to not being able to provide appropriate supervisor. For all of these circumstances that we outlined, Your Honor, we're asking the court to grant my client an evidentiary hearing on the questions of legal and physical custody. Another event that we mentioned in our motion is plaintiff's refusal to cooperate with scheduling an emergency orthodontist appointment for the older child. My client has since been able to do that, but plaintiff did not cooperate, which is one of the reasons we're seeking for my client to have sole legal custody. Thank you, Your Honor.
Okay, thank you. Mr. Bailey?
Thank you, Your Honor. I know the court doesn't know me. I'm new to this jurisdiction, so just bear with me, Your Honor. I've been doing this for a long time. I find it very frustrating when a party takes facts and spins them. I like the word spin, and leaves out other facts. Much of what the defendant has brought up here is hearsay. The children said this, the children said that. Well, that is generally not a basis for changing anything. The court, they have asked for an evidentiary hearing, which could be appropriate. I will discuss that in a moment. Addressing their motion item by item, my client believes what started this whole process, and the court is fully aware that these parties were divorced on December 13th. The defendant signed his motion on February 3rd. That is it's less than 40 days, I believe, after the judgment of divorce was entered. He's back in court trying to redo everything. There simply is no basis for that. My client picked up the children one day. Their two young daughters, who I believe are 5 and 8, and they told her that their aunt, who does daycare for the defendant, before school care, I don't know, after school care, had choked one of them. That was very concerning to my client, and I believe she called CPS, and that upset the defendant because that would take away his free daycare. At that point, CPS was called, and that was, my client believes, the reason for the filing of this motion. She's not being evicted. She rents a home where the parties lived prior to this and where the children have lived for some time from her aunt and uncle. The reason I find it interesting that the defendant is so knowledgeable about the status of my client's housing, but she's not in the process of being evicted. She's made arrangements to stay there with her aunt and uncle. And so that's not going to happen. Further, one of the reasons that they were considering evicting her was that the aunt received a very nasty, verbally aggressive phone call, allegedly from the plaintiff. When the plaintiff talked with her aunt, they discovered that this was made by a third party on a blocked number. So it looks like there's some shenanigans going on behind the scenes here, trying to get my client evicted to give their motion, the defendant's motion, more of a basis. There's an allegation of drinking and partying. My client does not drink with the children. They did have a Thanksgiving party where children and adults were present, and there was some modest drinking. That was in Thanksgiving, prior to the entry of the judgment of divorce. That's a moot point at this time. They did not provide any specific allegations of my client's drinking or partying, which is a problem throughout this whole motion, is it's innuendo. There is no specifics here. Oh, she drinks a lot. Well, give us some examples. There are none. It's just that she drinks a lot and she should lose her custody. Not a basis to lose custody. They need proof. She has access to a vehicle to get the children to school and activities, but the children take the school bus from the driveway in front of her house. That she does not have to drive them to school because they have transportation for that. But again, she has access to a car and will be getting a car of her own in the near future. She is starting her own cleaning business. She's getting that off the ground. So she is not fully employed, but she is employed and looks forward to being able to take care of her own financial needs and her children's financial needs. People lose jobs, people are in between jobs. That again is not a reason to change any custody. I think to her benefit, she's not gone back and asked for a change of child support because she has less income than was calculated during the judgment. This report, the police were called and did a forensic interview. I've never known of a police officer who had the training to do a forensic interview. It's always done by a psychologist or a social worker who has training in doing a forensic interview. And again, the police told him to not let the children go back. Again, that's a hearsay statement. We don't know what the police told him. There's something about the children being locked in their rooms. My clients provided me photographs, and I don't have the ability to get them to the court today, but they will be presented later if need be, about the children being locked in their bedroom. The doors don't have locks, and my client does not lock the children in their bedrooms.
Okay, sir, don't speak while, we're not taking any testimony from you, so.
Thank you, Your Honor.
Go ahead, Mr.
The dentist, the children were taken in for, I believe, a biannual cleaning and checkup. And the dentist told the defendant that the children, the one daughter had an emerging tooth that was going to be a problem. I'm guessing the court might have children and grandchildren. I have children and grandchildren. This is a common problem. It's not an emergency. The parties actually talked on the phone and texted about it. Appointment was set up on February 27th, well after the scheduling and filing of this motion by the defendant for an orthodontist appointment. He did not inform my client of it. My client is not standing in the way of her daughter getting proper medical care, but there simply is no documentation that there's an emergency. It's an 8-year-old who has an emerging tooth that's going to interfere with other teeth. That's very common and will be dealt with by an orthodontist as they see fit, but not an emergency, not a reason to take away joint legal custody. There is no proper cause here. There's no change of circumstances. It's been 2 months since the entry of the judgment of divorce. We're asking that their motion be denied in its entirety, Your Honor. I don't know your practice. You were on vacation. I don't know if you would have even signed this without a hearing. So we're asking again that it be dismissed completely and that my client's parenting time be reinstated. And briefly, she's asked to see the children at McDonald's. She's called a facility that does supervised parenting time, but they are booked up. So she has not been able to see her children in approximately a month now. I think maybe one quick visit somewhere, but that's it.
Okay. Anything else, Ms. Henderson?
Yes, Your Honor, we are ready to provide witnesses to corroborate all of the statements that are made in our motion, including the police officers that would testify. Mr. Bailey's response in several spots contained statements like allegedly or uncorroborated. This court's position is no testimony or evidence is to be provided on the motion day. We're ready to provide all of the evidence at the evidentiary hearing. And we state that the magnitude of changes that occurred since the finalizing of the judgment of divorce is such that custody needs to be revisited by the court, Your Honor.
Okay. Well, the court notes as I reviewed the pleadings, heard the argument today. Obviously, court is always suspect on someone bringing up a change of circumstances when it's been less than 2 months from the time that the judgment was in it. The court would not, for purposes of the subsequent evidentiary hearing, the court would not consider anything that occurred prior to the 12/13/2022 judgment of divorce. So it'd have to be any circumstances that arose after that. And the court would state that obviously it's a close call, but if the allegations are true, then the court would find that they have met the burden of VARCA for purposes of proceeding with an evidentiary hearing. So the court will grant that hearing, refer it to the referee for an evidentiary hearing. However, as I hear the plaintiff's response and that the court is not convinced that there was appropriate basis to enter an ex parte order in this matter, as Judge Yost Johnson did. So the court will vacate that order. So the court will refer the matter to the referee for a hearing, an evidentiary hearing on the motion. But I'll ask you, Mr. Bailey, to again enter an order which would vacate Judge Yost Johnson's order. And that means that parenting time would resume. I don't know if it's this weekend or just on the whatever the normal schedule was. And so you can put that into place, and that will be the order. The court will end this matter at 9:21 a.m. You're free to go. Have a good day.
Thank you very much, Your Honor.
Your Honor, may I please verify if Mr. Bailey will continue representing Ms. Barris? His appearance was just for the motion.
I can't force Mr. Bailey to do anything. So,
well, I just wanted to verify because he filed a very limited appearance for the motion hearing only.
That is correct, and I will be discussing going forward. I didn't know if there would be an evidentiary hearing or not, Your Honor.
Okay.
So now I need to discuss that with my client.
Okay, do that, and then I will hold you if you're not going to represent the plaintiff, Mr. Bailey. I'll at least hold you to do the order that court.
Yes, I will be doing that order forthwith.
Okay, thank you.
Thank you, Judge.
Judge, it looks like he's driving.
Yeah.
Let me send him a message. I'm sorry.
Yeah.
I'm telling him to pull over.
Okay. Yeah. Because I don't want him distracted and causing an accident. So I'm not going to proceed if he's still driving.
Okay. Thank you.
Ms. Yancey, you're still muted, so, okay. Thanks.
Brian, can you hear us?
Can you hear me?
Yes.
Yes.
All right.
Have you pulled over, sir? Looks like you have.
Yes, yes. Yes,
Okay.
sir.
Court will note the appearance of Ms. Sharp on behalf of the plaintiff, Ms. Yancey on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary final custody and parenting time. Ms. Sharp.
Thank you, Your Honor. Your Honor, my client is trying to address temporary parenting time. I believe that I believe that the parties will be going to mediation. We'll have to discuss that, Ms. Yancey and I, but my client, the parties have been separated for a while. My client has been trying to get additional parenting time throughout this process, but he has been getting during the school year alternate weekends simply because of how far he lives from the school. On the summer, they split week on, week off. My client has been trying to get additional parenting time throughout the school year with the understanding that, he does live away from the school. And so that is why he is requesting every weekend and also in the alternative to have every weekend with the exception of mom having at least one weekend per month. And mom have the other parenting time during the school year at this point. The parties also are discussing that the school may change. That has not happened yet. But at this point, the child is still dad's probably about 45 minutes away from the school. And so ultimately, Your Honor, my client is asking for every weekend during this school year. And he was asking for additional summer parenting time other than just, week on, week off. But that's what the parties have been doing is week on, week off. And the alternative, he would request at least every weekend with the exception of mom having one weekend per month during the school year, that the parties alternate holidays, and in addition, that they split the breaks. I believe these parties get along other than, just the fact that my client is just trying to get additional parenting time, and these parties have never had any kind of custody order in place. He would request also joint legal, joint physical parenting time, custody. Thank you.
Okay, Ms. Yancey, your response.
Thank you, Your Honor. Your Honor, this matter actually did start in Berry County. Mr. McGregor filed there indicating that that was his residence. That was filed last year. We went through some litigation there, and the judge required that Mr. McGregor prove his residency in Berry County because he was actually doing an adoption of his step children. That turned out to be not in Berry County. That was not his residence. So the matter was to be transferred to Calhoun County by December 17th. He had counsel, which was not Ms. Sharp. At that time, we still had not heard anything. Ms. Sharp did get involved. She did provide me with a courtesy copy of the filing, which I appreciate. But the fact of the matter is, Your Honor, we had to start all over because it was all new filings. My understanding was the transfer was going to happen to Calhoun County based on the pleadings that we already had. So that's incurred additional cost to my client. This child, Your Honor, will be 9 years of age at the end of March. And this entire time, he has always lived with my client. The parties were not married when the child was born. So my client does have legal and physical custody of the child. And in order to establish any kind of a change, Mr. McGregor would have had to have provided in his pleadings that there's some basis for that modification or change. All of his pleadings indicate are just the steps of what the best interest factors are, no examples of anything. In our response, we provided the fact that my client has always provided housing support and clothing for this child. She takes care of all of his education. She takes care of all of his medical and his dental. Her husband actually has medical insurance on the child. The child has never had medical insurance from Mr. McGregor. Mr. McGregor has never provided any child support for this child for these 9 years. My client, even with all of that, has always included him in all of the appointments that are available and all the school functions, and he chooses not to come. My client does give him, without benefit of an order, every other weekend. He picks the child up from school on Friday, and then he returns the child to school on Monday morning. So he actually gets more than just the standard. He gets 3 overnights on his weekend, and he does that every other weekend. He does not exercise a midweek visit. They did try that. My client offered that to him, and he only took that advantage maybe 2 or 3 times and then stopped doing it. He does have parenting time in the summer of an every other week that the parties have done. So, Your Honor, our position is there's been nothing established through his pleadings that would indicate that there should be any kind of a modification or change of the custodial environment of the minor child. The parties have been following for this, the child's lifetime, this parenting time schedule, which is more than the standard. And my client has cooperated with Mr. McGregor to provide him with information, and he makes the decisions not to change. He, by his own pleadings, he indicates that he can't do anything during the school year because of the distance that he lives. So it would make sense to just continue with the status quo in terms of what the parenting time is, deny his motion for any change of custody, and order a support review.
Okay, thank you. Ms. Sharp, anything else?
Yes, Your Honor. Again, there is no custody order in place, Your Honor. I don't believe that my client needs to establish a change in circumstance. I do state that the parties, I outlined what the parenting time has been, though my client has been requesting additional time. The reason he retained me was because of previous counsel not proceeding with what they were needing to do. We did try to actually transfer this case, and was told to just file a new case. And so that's what we ended up doing, is so that there wasn't any more delay on it. But my client actually is part of participating in any of the joint legal decisions. The parties actually were speaking about, the child is changing schools and possibly going to a private school due to some kind of, I guess there's some aggression or fighting issues, not that the child is the victim here. And so the parties have been discussing that. So my client has participated in joint legal decisions throughout the child's life. And so again, I believe that he should at least have joint legal custody at this point, and he should be given the ability to have additional parenting time because he has been trying to get that. And it's not his fault if it was filed in the incorrect county. He had to make sure that he got new counsel to be able to do the correct thing. Thank you.
Okay, thank you. Well, what the court's going to do in this matter, does appear that there's a long-standing history in this particular case, and the court is going to, at least on a temporary basis, is going to continue the status quo, which provides, I would say, based upon what I've heard, that the plaintiff would have joint legal custody, but the defendant would retain the physical custody of the minor child, and the court would continue the parenting time that the plaintiff has had, which is alternating weekends, Friday through Monday morning, alternating holidays, alternating breaks, and alternating weeks in the summer. And that would at least continue us until such time as we would be able to have a hearing. The court's not going to change anything without taking testimony and having a hearing in this particular matter. So that's what the court will do at this particular time. I would order that the parties would each exchange income information with the other party, and that I would leave it up to the attorneys to calculate the support based upon the income that the parties disclose. And especially now, hopefully the parties would have their tax returns done for 2022, so we'd have an up-to-date record of what the incomes are. So, Ms. Sharp, I'll let you prepare the order and submit under 7-day notice. That will conclude the matter at 9:33 a.m. You're free to go. Have a good day.
Good morning.
Thank you. You too.
Good morning.
Morning.
iPhone, please unmute.
Good morning.
Good morning. iPhone, first and last name, please.
Dominic's favorite.
Okay. Ricky?
Yep.
Okay.
Court will note the appearance of Mr. Todd on behalf of the plaintiff and Mr. Umloff on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary parenting time and custody. Mr. Todd.
Thank you, Your Honor. Your Honor, prior to separation, the parties equally participated in child rearing, and that was the status quo. In essence, basically, the parties partook in joint legal and joint physical prior to separation. Since separation, The defendant has been obstinate towards the plaintiff in terms of really any significant parenting time. However, the defendant continues to call every single day to try to remain in a relationship with the child. In terms of the response, there have been no CPS substantiations of any sort. There was an investigation. The defendant called on plaintiff, and that never resulted in anything. The defendant or the plaintiff has no criminal history outside of a speeding ticket. In terms of the housing for the minor child, the plaintiff does live with his mother at his mother's house. However, the child has his own room and has everything in his room ready to go. There was never any domestic violence charge. We would deny any substance abuse issues. Mr. Favorite does not drink. He does smoke marijuana occasionally. However, he is certainly open to any prohibition upon smoking or drinking during parenting time. In terms of the allegations of any guns, to the best of his knowledge, the child has never had any contact with firearms, unloaded or loaded or whatever. In terms of the firearms that are at his mother's house, there are firearms at his mother's house. However, these are in a locked box, which is in a locked room. There have been no proof of any of the allegations. The defendant is basically trying to paint a picture of plaintiff that he is some kind of horrible person who's abusive. That's actually not accurate whatsoever. He is part of a Christian men's fathers group to help him deal with this parenting time issue, help him become a better father, and help him basically cope with not being able to see his child right now. In terms of the allegation of waterboarding, what happened was that the child got some shampoo in his eyes. Nothing more than that. We have no issue at all with a stipulation that there would be no corporal punishment for the child of any kind during parenting time. We don't believe that there is any reason for the court to not have joint legal and joint physical custody in this particular matter.
Okay, thank you. Mr. Omloff?
Your Honor, as I noted in our response, the parties separated in May of 2020. And since then, the plaintiff has seen the child only sporadically, approximately 1 or 2 times a month with no overnights. During that time, the plaintiff does simply watches his girlfriend interact with the child. He does use marijuana excessively, drives while high, and my client is observed him hitting mailboxes. While doing so, he becomes irate when he's asked to stop. He has threatened to kidnap the child in the past. As far as whether or not the child has his own room at the plaintiff's mother's house, that may be, but there are not enough bedrooms for all of the occupants in that house. As far as the allegations of domestic abuse, they're clear. The plaintiff beat my client multiple times per week while they were together. He threatened her with a gun. He threatened to kill her family. In 2019, my client got a PPO against him when he chased her with a knife, pinned her down on a bed, and tried to stab her. And the reason that he became upset with her was she had just found out that he was sleeping with her cousin. That PPO case was in this court, bearing the case number 2019-2541-PP. The plaintiff did not dispute any of the allegations or contest the PPO in any way. The incident that was referred to in plaintiff's initial motion occurred while the plaintiff was in the United States Marine Corps. He committed an act of domestic violence against my client and then subsequently intimidated her into not pursuing charges against him. He says he's not at fault for any of this. He just blacks out when he's angry. To say that because there's been no criminal charges or criminal convictions against the plaintiff is frankly sad, given that victims of domestic abuse often do not report this or call the police out of fear for their safety. And that's what happened in this case. Tegan suffers from hemiplegic migraines, which can cause bad body aches and paralysis. Thankfully, he is on medication, which has, for the most part, prevented any paralysis issues. Tegan also suffers from anxiety and is currently wearing a heart monitor. What cardiologists try to determine if he suffers from a specific heart condition or if his heart just at times beats abnormally fast. Unfortunately, the plaintiff has made no effort to educate himself on how to deal with these issues, and in fact disputes that they even exist. To clarify or make a correction on what was in my response, the incident that happened when my client observed Tegan playing with a firearm that thankfully was unloaded occurred at Dominic's grandmother's house. That is the plaintiff's grandmother's house. I accidentally misunderstood my client and put that it happened at Dominic's mother's house. Furthermore, plaintiff's mother did admit that she once left a gun in Tegan's toy box while she was drunk. The plaintiff has left his depression and anxiety medications out. Tegan ended up playing with them, but thankfully did not ingest any of them. The plaintiff has hit Tegan so hard he's left welts in the back of his thighs, and would also instruct Tegan to hit his mother. I will also note that the issue of child support was not raised in the plaintiff's motion. We request that child support be paid according to the Michigan child support formula. We would ask that my client be awarded sole legal and physical custody, and that the plaintiff have supervised parenting time at Family and Children's Services or a similar entity, rather than by his own family, who frankly function as his enablers. We would further, ask that there be no corporal punishment or use of any substances during parenting time. Thank you.
Okay, thank you. Anything else, Mr. Todd?
Your Honor, again, we have no issue with no corporal punishment during parenting time. We have no issue with no drug or alcohol use during parenting time. It was actually the defendant's request that while the plaintiff was exercising parenting time, his girlfriend come over, and we deny any of those allegations in regards to this alleged domestic violence incident and how that allegedly happened. Again, my client deserves the presumption of innocence. We have no verification outside of allegations of that anything occurred. Additionally, the plaintiff has made an effort and continues to make an effort to see the child, and he's been denied that opportunity. In terms of the child support, he actually called Lansing before calling me to try to set up that child support process moving forward. So we are respectfully requesting the court order joint legal and joint physical custody.
Okay, thank you. Well, in this particular matter, the court does note that, again, the parties have been separated since approximately 2020. It does appear that the child has been in the care of the defendant for this time. So the court is going to, on a temporary basis, grant to the defendant the legal and physical custody. The court will grant to the plaintiff parenting time, standard Calhoun County parenting time, with the midweeks to begin this week on the 8th, on March 8th, and then the alternating weekends to begin on March 17. I will grant to the defendant the spring break of this year, and then we'll talk about the other after this particular point. Court notes that the plaintiff has agreed that he would not drink or consume marijuana during the time he has the child in his care, so the court will order that. The court will also order that there be no corporal punishment, and the court will order that, again, that the plaintiff would be required to provide the child with all of the child's medication and any other medical treatment that is the child is going on at this point. If he's got some sort of a apparatus or something of that nature that the child has to wear or monitor or something of that nature, the court will order that. And the court will order that the plaintiff would pay child support consistent with the child support guidelines, and would order that the parties would exchange their income provided to the other attorney within 10 days of today's date. With that, I'll ask Mr. Todd that you would prepare that order and submit it under 7-day notice of entry. That will conclude this matter at 9:45 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
123
Thank you, Your Honor.
ADP Mitchell Upright versus Jennifer Wilson. Today is Monday, March 6, 2023 at 9:46 a.m.
Court will note the appearance of Mr. Sackrider on behalf of the plaintiff. This is plaintiff's motion to close the case. The court has read the motion. It does appear that we did have an evidentiary hearing on February 1, 2023, whereby the court did revoke the affidavit of parentage. And it makes sense, unless you have something else, Mr. Sackrider, that the court would close the case. Have you requested your motion? I've not gotten any response from the defendant in this regard. A court will note is now 9:46 a.m. The matter was set for 9 o'clock a.m. I'll ask you, Mr. Sackrider, I don't know, do we have an order in the file? And you're muted, so.
Yeah, there should be an order there.
Okay.
Very simple. This order closes
Okay.
the last pending claim.
Okay, we'll get that sent to me and I'll get it entered after this hearing.
All right. Thank you, Your Honor.
Okay. Thank you, Mr. Sackrider. That will close the case at